As Mark indicated, my background is that I've been involved with elder law for over 30 years. My legal career started as an assistant attorney general for the state of Connecticut for then Attorney General Joe Lieberman. And one of the things that Joe used to say to us is that, talk in terms that people can understand. Don't talk in legalese. It's important for people to understand the law and have it work for them. My job at the Attorney General's office was to prosecute Medicaid fraud cases. And 9 times out of 10, people weren't out to dupe the state of Connecticut. They just got horrible advice. And that was one of the things that when we started our practice over 30 years ago, that we wanted to make sure that, people are educated in how to protect, what they've worked a lifetime for. I'm a former national chairman of the Senior Rights Political Action Committee, and we've done a lot of work both nationally and in the state of Connecticut. People often say, how can we approach your parents and your loved ones to talk about long-term care issues, to talk about financial issues, to talk about many different issues that affect aging. I often get asked this question: when is the appropriate time to have what we call the talk with your aging parent or relative? There's something out there called the 40-70 rule, and what that says is that if the adult child is 40 or older, and the adult parent is 70 or older, that's the time to really start sitting down and addressing these issues. And I can tell you,
no, we did.
Both, can we ask you to put yourself on mute unless you have a question for Dan? Thank you.
The 40-70 rule just means that that's a benchmark for when you want to start talking about long-term care issues, healthcare issues, and having the discussion. I can tell you, with over 30 years of practice in this area of law, that the families that have the discussions, that educate themselves, that have their documents in place, fare far better than those who have done nothing, have avoided the conversations. And when that event occurs, they're scrambling to try to make up for time that they could have had a plan in place. As a matter of fact, studies show that 1/3 of adults in the United States have a major communication obstacle with their aging parents that stems from the continuation of the parent-child rule. Sometimes parents still look at us as being the young tyke in the backyard running around and riding on the bike. But it's important to try to facilitate that. And we're going to give you some tips on how to do that as we go forward. Another study done by AARP found that 2/3 of adult children never had a frank discussion with their parents about the long-term care and end-of-life arrangements. So statistically, we're seeing that people avoid this. They don't want to deal with it. And that's not the right route to go. Most adult children put off talking to their aging parents about legal, financial, healthcare issues because, frankly, it's uncomfortable, but it's a discussion that needs to be done. Making an effort, as I indicated, to address the subject can lead to both peace of mind for the parent and the child, and can come up with much more favorable results if there is a healthcare crisis. Well, how do we do it? How do we approach our parents? How do we approach our loved ones to discuss long-term care issues? Well, one way to do it is to have your own legal affairs in order, that you may start a conversation with a parent saying, hey, I just went to see an elder law attorney. I had my will updated. We had a trust done. We have a power of attorney, a healthcare representative, a living will. So you're saying, I've done this. What do you think about it? That's a great way to broach the subject, to try to set up maybe a discussion. We often say around the holidays, that may be a good time. Everyone's sitting around the table, maybe after dinner, saying, hey, there's some things I wanted to tell you. And again, the great icebreaker is, I've taken care of my legal affairs. I've started to protect myself and my family. Maybe we should talk about you. You want to make sure you have the appropriate tools in place to deal with having your affairs in order. And that's making sure we have certain legal documents. The goals of the adult child should always be trying to balance safety issues. And we often see that when parents are, we're concerned about them driving. They may be getting in multiple accidents. They may have issues that their reactions are slow, and they may have vision and cognitive issues that we just don't think it's safe for them to drive anymore. But we have to balance the safety issues with those of independence of our parents and of our loved ones, because that's a big deal. Driving is a very big deal for many individuals. It's giving up control of their life. It's giving up their independence. So we try to balance these issues so that have a conversation. So we don't want to wait until there's an emergency to have these meetings. It's important that we take into consideration. If anyone is interested, we've put together a packet, which we'd be happy to mail out to you, and you can just give Mark your address or go to our website, which is www.ktelderlaw.com, and we'd be happy to send you articles that we've written about having the talk and some other ways in which you can broach the subject with your parents. One of the things that we note in some of the articles that we've written is that when we start a conversation, we probably don't want to start out with, Mom, Dad, have you done a will? Where is it? It's important that they have a will, but it may be better to start off with, Mom or Dad, do you have a power of attorney? Do you have a healthcare representative? Oftentimes the children don't want to be seen as coming off as greedy or wanting to take over their parents' assets. That's a better way to present it, that not, do you have a will? Let me see the will. Do you have a power of attorney? What if we had to make financial decisions for you if you were incapacitated? And that's what a lot of people misunderstand also, is just because you're married doesn't mean you have the right to access your spouse's finances, their IRAs or 401ks, anything that may be in that individual's name alone. Just because you're the adult child of a parent does not mean that you have any right to access any of their finances or get financial records. And that's extremely important if we're applying for Medicaid Title 19 or many different programs. You need to be able to access their finances. So it's important that we have certain documentation in place. Again, parents fear the loss of control, the loss of independence, but you might be surprised to find out that Boston College Center for Aging had done a study many years ago, and what they found is that most parents are more willing to discuss long-term care issues, end-of-life issues, than their adult children. And you might find that surprising. You would think it would be the opposite way, but the studies show that is a way that's not the way it is. So many times a parent may be just waiting for the adult child to bring this subject up. You want to be proactive. And again, as I indicated before, by bringing this to the forefront, by suggesting it, you're going to get better results as far as getting the best care possible for your loved ones, making sure that their assets can be protected, knowing that there's many different options. We want to make sure we're constantly educating ourselves on the ever-changing laws that affect long-term care. So that's important to do. Some of the questions we may bring up in these conversations, having the talk is, do you have a safe? Do you have a safety deposit box? Do you have these long-term care issues documents? We call them advanced directives, which are a living will, a healthcare representative, a HIPAA or a privacy form. Do you have these? Where are they? It really doesn't do much good if we have all these documents and they're locked up in a safety deposit box. We want to make sure that the people that we've appointed in this under these documents know where the originals are and know how to access them. So that's an important question to ask.
Hey, Dan, I just have one kind of observation, and thank you. Really good advice so far. Is in terms of tabulating and organizing legal documents and key contacts, I'm a big fan of putting together like a summary binder where it's all located in one spot with key contacts, wills, life insurance policies, marriage certificates, death certificates, even veterans discharge paperwork, because that day will come when you're going to need to look for that. And if your loved ones were like my loved ones and they had things in 15 different drawers in 15 different rooms and no sort of organization, it's going to be another crisis in a crisis. So if you get nothing else out of this talk, have the talk and make sure you know where their important documents are located.
That's an excellent point, Mark. And that, I've had engineers over the years who have done just that. They've had everything laid out for their family members. Years ago, I gave several speeches around Connecticut with an author of a book, Lynn McPhillamy, who's a fabulous person. And the name of her book was In the Checklist of Life. And she was on Oprah Winfrey and other shows. But her book was basically what you were saying. It was a book where you could fill in the blank. Who's your doctor? Who's your lawyer? Who's your accountant? What your wishes are for the end of life, so that there was one spot and they'd say, look at the bookcase. This is where all my instructions are. And Mark makes a great point. That makes life so much easier if there's a roadmap for people to follow and what would happen if we can't communicate what our wishes are. And that's kind of the reason behind a lot of these legal documents is what happens if we become incapacitated? Who's going to make financial decisions for us? Who's going to make healthcare decisions? And if there's 4 children in the family and one child is the most responsible one and the one you want to make sure is making the decisions for you, you've got to put it in writing, or it may not happen. Or the one who you don't want making the decision, which might be the one who's still living in your basement wearing the Foxwoods jacket, that's the person who wants to make the decision. So these are things that we want to take into consideration before we do that. It's important as we age that our family knows what our financial portfolio looks like. Why is that? Because if we were to apply for veterans benefits, if we were to apply for Medicaid Title 19, essentially both of these organizations want to know every asset we have. And that includes looking at cash values on life insurance. And I'm going to touch a little bit later on the basics of Medicaid Title 19, because it's important to know that. Because many times people are eligible for benefits and they're not told that, they're not even aware of it. Again, I know there are people here today that were preaching to the choir if they're involved in long-term care, if they're involved in assisted livings or nursing homes. The one thing to bring to mind is that elder care is not just about seniors. It affects the whole family, and it can have a ripple effect, and it can be very, very problematic for the entire family. So that's why we want to discuss these issues, get started early, making sure that we have plans in place. Connecticut is a unique place in that there's some very positive things about aging in Connecticut, and there are some negative things about aging in Connecticut. And one of them is the cost of long-term care. And a skilled facility in the state of Connecticut, it could be in excess of $200,000 per year if our loved one needs long-term care. So we would want to make sure that we're getting the best care possible and reducing our costs. And again, we've touched a little bit upon some of the reasons that the children are hesitant, the adult children, to have the talk. They're concerned that their parents may not have an estate plan in place. They're concerned that the parents may not have a long-term care in place. They may be concerned that they're not legally equipped to assist their parents, which is absolutely the case if the power of attorney, healthcare representative, and living will are not in place. In many cases, the adult children have absolutely no idea what their parents how they stand financially, whether they have significant assets or a lot less than what they thought that they had. So that's important to know, that if we might be eligible for benefits and we're not even discussing it. One of the things.
Question.
Sure.
Is there a point, human nature, people put things off. Is there a point when it's too late, or even, if someone's here, even hospitalized, at that point, can the talk still happen and happen successfully or not?
Great question, Mark. Absolutely. One of the things that we're going to talk in just a moment a little bit about Medicaid Title 19, but if you have a married couple, if you have one of the spouses is in a long-term care facility, even if they haven't done any planning, at that late date, certain things can occur. If they're still capable, they can sign documents. There's many times that we go to hospitals or assisted livings or nursing homes to get signatures because the documents that they should have had in place, they didn't. Many times people think that it is too late to address these issues. And in most cases, that's just not the case. There's things that can be done. And unfortunately, some people believe that and they don't do anything when they could address the issue. Obviously, it's a lot easier on the individuals, on the couple, on their family, if they have certain documents and a plan in place. But it doesn't mean that it's too late to plan. And one of the things that I wanted people to take away from my speech here today is, and anyone who's heard me speak in the past, is something I talk about all the time, is be really careful who you're listening to, because people may be well-intentioned and they could be giving you horrible advice. I had a meeting earlier today, and this family had consulted with their accountant, and we were talking about a married couple, and what the accountant said, well, if one of these spouses cashes in account and then puts it in the husband's name, that'll create a 5-year penalty. Well, that's just not true. And this is an accountant that the family was depending upon for accounting advice, probably wanted to help them out as much as they could, but they were giving this family horrible advice. It's just not true in the Medicaid Title 19 arena. You know, oftentimes family members try to help you out and they say, well, this is what happened when we had mom and dad, and this is what we did. And your parent is a widower, or a single person. Totally different rules. So you want to be really careful.
Hold on one second, Mary.
Who you're listening to, because many times that information can be wrong. Let's talk a little bit about Medicaid Title 19, because people often are very interested about that and how to protect your assets. As I indicated before, there are totally distinct rules for when we're talking about a married couple and when we're talking about a widow or single person. Oftentimes people come into our office, they're very distraught. They say, well, my husband's going into the nursing home, we're going to lose our house. And I say, no, you're not. The home, when we're talking about a married couple, is an exempt asset as long as one person is capable of living in the house. It doesn't get counted. It can't get liened. Now, that's different than your vacation property, your rental property, your business property, your home, your residence under Medicaid Title 19 for married couples is an exempt asset. Now, that's a little different when we're talking about a widow or single person, and we have to decide what program are we talking about. Someone being in a nursing home, or are we talking about the Connecticut Home Care Program, or are we talking about the Connecticut State Waiver Program for home care? So that's different. And the rules for eligibility are significantly different between married couples and single individuals. For a single person in many of the programs, they have to spend their assets down to below $1,600. And that includes cash values of life insurance. That includes annuities. That includes any type of investment that the family can gain access to, regardless of what the penalties would be, regardless of what the taxes are. The state says, if you can access that, and again, we're talking about a single person, a married, not a married couple, that person has to access those assets and use it for their care. But how they spend it down can come many different ways in which that can be done. When we're talking about a single person and they're applying for home care, they're living in their home, one thing that we often feel isn't disclosed enough is that the state in many cases is going to lien that property. And we feel that families should be advised of that before they apply for any home care program, because it's great that they're getting care in their house, but it's not really for free. And you should be advised of that. One problem we see very often when we talk about married couples is they're often told that, yes, your home is exempt and your assets are exempt up to $130,380. Well, it can be protected a lot higher than that. But there's a way in which legally you can go about protecting far more than what the state says you are entitled to. Completely legal, completely ethical. We've been doing it for many, many years. Everything is disclosed to the state. Here again is an example of how, depending upon who you're listening to, it could cost you significantly. We had a case last year that we inherited. I say that we inherited because this family didn't start with us. This was an unfortunate gentleman, was 65 years old. He had to go into a nursing home because he had Alzheimer's. The family did pretty well. They had a home and $600,000. An elder law attorney told this family that They had to spend down $500,000 before this woman's husband could become eligible for Medicaid benefits. Well, that's not necessarily true. And she started spending $15,000 a month on her husband's care. And one day she was upset, and as I would be if I were paying $15,000 a month for my wife. And as luck would have it, her husband's roommate was our client. And the adult son was there and said, you better go see Attorney Tully. When this woman came to see us, we felt horrible because she already spent $300 of the $600,000 that we couldn't get back. But we showed her a way in which she was able to protect the remaining $300,000. That could have happened with $600,000. Again, you've got to be extremely careful who you're listening to. Obviously, your loved one's health is first and foremost. Making sure they're safe is first and foremost. But you work very hard for what you have, and you want to make sure that you don't lose it. You want to make sure that you're accessing under the Medicaid rules some assets that are exempt. In a married couple, the home is exempt. For both married couples and single individuals, widows and widowers, is a prepaid funeral contract. Now, if you're going to have a traditional funeral, that easily could cost $10,000 or more. That can be set aside as long as it's properly in an irrevocable funeral trust, and the state would not be able to have access to that. Those funds can gain interest over a period of time. And many of the families that we've dealt with over the years have said, we're glad mom or dad had the funeral contract set up in advance because that's less that we had to worry about when they passed. So those are ways in which you could spend it on a funeral as opposed to just spending till you have nothing left. There are also items that you could purchase that's going to make your loved one more comfortable. If there's a need for medical devices, even in a scenario where they're in a long-term care facility, or if they're at home, it could be spent in ways. You're entitled to have a car. And there's many different assets that are exempt that you don't have to necessarily spend down. The biggest question we often get is families are concerned about, I'd like to make a gift to my child. I'd like to make a gift to my grandchild. What are the rules? What's the look back period? Am I prohibited from doing that? Well, in the state of Connecticut, and that's an extremely important fact to make, many times we may read publications that are written for the entire country or for Massachusetts or Rhode Island or New York State. Every state is different. Even though Medicaid Title 19 is a federal program, it varies differently from state to state. And unfortunately, in the state of Connecticut, we are very conservative. And many things that others are allowed to do in even New York and Massachusetts, we cannot do here. So if someone's trying to tell you what happened with their parents in Chicopee, Mass., that's not the state of Connecticut. And you can get yourself in a lot of hot water if you're listening to someone who's from a different state where the rules are administered differently. But if we do have a situation, we could look at the look back period. Right now, since the year 2006, there's a 5-year look back if we make any gift whatsoever. And oftentimes I have folks come into my office and say, Attorney Tully, I've got 2 kids. I've been told I could give each of them $15,000 tax-free per year. That's correct if we're talking about tax. But what we're talking about in this case is Medicaid asset protection planning. You could give away $15,000 to your 2 children tax-free, but that just created a 5-year penalty or a 5-year waiting period before you'd be able to apply for any benefits. So the 5-year look back was a big change in the law back in 2006. And unfortunately, part of the law change was based upon misinformation that they were claiming that everyone was giving away their homes and their assets, which actually the Robert Wood Johnson Foundation and the Institute of Living did a study that showed the majority of individuals, at least in the state of Connecticut, were not giving all their money away. And yet Congress passed this law, which has made it much more difficult for families applying for Medicaid Title 19, because you can imagine the paperwork that would be generated by a 3-year look back. Now we have 5 full years of paperwork that has to be submitted to the state and explaining all deposits or withdrawals greater than $1,000. But the look back period in general is a 5-year look back from the date in which you're applying for Medicaid benefits. You'd have to supply all of your monthly statements on all of your finances, and explain the transfers that occurred during that period of time. It sounds daunting, and it can sometimes the application process can be a real bear, but in many times it's worth the effort because, as I indicated before, sometimes individuals are eligible long before they ever thought they were, and it's kind of maddening when you're in my position and you hear about people who could have been eligible years sometimes earlier for their loved ones, and they don't know that, or they're given horrible advice. So that's something that we want to be aware of. Oftentimes when we're talking about gifting too, we want to be very careful that we're not creating taxes depending upon what type of asset that you are transferring. You know, people often ask me what my position is about transferring gifts to the children. And one of the things that we often want people to be aware of is many times married couples don't have to give away their assets to qualify for Medicaid Title 19 in their home or in a long-term care facility. You know, we often hear people complaining about the state of Connecticut. And one of the things that Connecticut has done correct is that they've really expanded and put a lot of effort into making sure that Connecticut residents can stay in their own home. In many cases, they can receive 24/7 care right in their own home. You have to qualify for the income and asset rules. But again, many times they're eligible for that and they don't even know it. And it's, you know, that's one thing that Connecticut's got right. We're always fast to turn on the state and say everything the state is doing wrong. You know, that they should be applauded for the efforts that they put into making many seniors have the ability to stay in their own home. But when we're talking about gifting, one of the things that we have to be very, very concerned about if we're making a gift to our child or grandchild is what if you had to get that money back? Remember, there's a 5-year waiting period. What if your child is going through divorce and you put the house in their name and all of a sudden your home is subject to a divorce proceeding? What if your child doesn't know how to manage money? You put assets in their name and that money could be gone. Bad investments, or they just blow the money. You could have the greatest kid in the world and you put an asset in their name and they get in a car accident and kill someone. The funds that are in their name, legally in their name, no longer yours, could be subject to litigation. You know, so that's very, very dangerous. There's many different things. God forbid if you put the money in your adult child's name and they pass before you, then those assets would pass according to the terms of their will, not necessarily yours. So we want to be real careful before you do that. Many times we see cases where people just make gifts at the end of the year based upon recommendations from financial planners or accountants or something that they've read in the newspaper without thinking about the repercussions of what could occur.
And we do have a question from the audience,
okay.
Which on this topic in terms of getting reparable advice. I know a lot of people, their primary source of advice is maybe their hairdresser, which, you know, they're great at doing hair, but maybe not on legal.
Right.
But
Right.
The question is, when researching reputable elder law attorneys, what are some of the qualifications, certifications that a family can look into, or maybe some good search engines that they could maybe utilize to find an appropriate qualified elder law attorney?
Right. Well, that's a great question, and we write a newspaper column in both the Bristol Press and the New Britain Herald, and I know we've written that article many times before. Every attorney is not an elder law attorney. You may have the best real estate, divorce, or criminal attorney in the state of Connecticut. They may not know anything about elder law, elder care issues. A great source of finding out about elder law attorneys is the National Academy of Elder Law Attorneys. I sat on their board many years ago, and they have a listing of elder law attorneys in the state of Connecticut. They often have their experience under what they call the experience registry. But just as a consumer, there are certain things that you should ask. Obviously, the person who does 2 Medicaid applications, Medicaid Title 19 applications per year, probably doesn't have the experience of someone who does 250. How many years have you been practicing in this area of law? Have you ever written on the topic? Have you ever spoken professionally to other attorneys on this? You know, you're the consumer. You have the right to ask and get all this information about the person's experience, the person's expertise. So that's something that you definitely want to take into consideration. Sometimes you may want to get a referral from your accountant or financial planner if they work in this area. There's ways in which you can check the background, and there are some designations of certified elder law attorneys in the state of Connecticut. But the same is true about how much experience someone has, how long they've been practicing in the area. That should be, a real indication of the devotion that they have to this area of the law. And it's changing all the time. So you'd want to make sure that someone who's been doing it and is up to date on some of the changes. And I think we're going to start seeing even more changes as we go forward in the future. Mark, was there another question?
That's it for now, Dan. Thanks.
Okay, sure. But you want to give some serious thought before you just give your assets away, and make sure that you're not going to lose what you've worked your lifetime for in fear of losing it. Oftentimes, if someone comes in my office and I feel that they're too young and in too good a health, I tell them, that you really shouldn't make a transfer at this point. You shouldn't transfer your home. Your home, in many cases, is the biggest asset that someone has. Now, if you bought your home in 1955 for $40,000 and now it's worth $340,000, you can sell the house tomorrow and not pay a dime of capital gains tax. But if you quitclaim or gift the property to your children and they sell it down the road, they will be paying a capital gains tax because it's not their primary residence. And that's some considerations that you want to give before doing it. That doesn't mean if anyone out there has transferred their home to their children, they should transfer it back. But you want to take these things into consideration before you make that transfer. Many times the biggest asset that people have. And, again, we talked about the dangers of transferring an asset out of their name. And legally, under Medicaid Title 19, that is one of the ways in which you can protect yourself, but it has to be out of your name, out of your social security number, and out of your name for a 5-year period. But that doesn't mean, again, Mark, you asked a question earlier about, people planning at the 11th hour, or if they're in a crisis. We wouldn't want someone not to seek out information thinking that it's too late, because there's often many things that can occur. For example, a year ago, we had a call from a daughter who left her life in Florida, moved back to this area, took care of her mother who had Alzheimer's, kept her out of a nursing home. And she finally got to a point where she could no longer keep mom home anymore. And rightfully so. One person cannot take care of another person 24/7. It'll wear you down. So mom's health got worse, and she placed mom in a long-term care facility. And she was told that, she would have to sell mom's home and spend the proceeds before she became eligible. Well, this is a very sharp person. She was a school teacher, and she said, you know what, this doesn't sound right. And she came to see us, and she said, Attorney Tully, that doesn't sound right. I said, it doesn't sound right because it's not right. You fit within an exception under the law where you provided care for your parent, kept them out of a long-term care facility. And that is an exception that enabled us to transfer the house to her. We applied for Medicaid Title 19, and it was granted because she fit within the exception. Again, we want to be careful who we're listening to, and make sure that you're getting the best advice possible. One trend we're seeing since the pandemic, a lot of people are providing care for their loved ones at home, and oftentimes the caregivers are adult children. And one thing that people don't often know is that the adult child could be compensated for the care that's provided for a parent. And many times they may say, well, I don't want to get paid. This is my mother. This is my dad. I want to give back to them. They took care of me when I was young, and now I want to take care of them. That's not the point. If someone makes a gift to you, there's a 5-year waiting period. If you're paid for services rendered, which you are providing, you may be taking care of them. You may be making meals for them. You may be taking them to the doctor. There are legal ways in which family members can be compensated and not have to wait a 5-year period. With that being said, the state is very finicky on making sure that there's an agreement between a parent and a child that there will be compensation. And we've seen that many times over the years. As long as you know what you're doing, as long as you're properly documenting everything, there's ways in which you can help your parent by keeping them home, but also helping them by protecting some of their funds based upon payment for services rendered. But again, there has to be certain documentation. There has to be something called a care contract defining what services the adult child will provide for the parent to keep them in their home. And they actually have to live with the parent, or the parent has to live with the adult child. And that's all in the state's law on Medicaid Title 19. So as you can see, there's many different exceptions under the law. But there are these carve-outs, if you will. There are these exceptions because the state and federal government takes into consideration ways in which, as if, for example, the adult child is saving the state of Connecticut taxpayer dollars by providing care and keeping a parent home longer. That person hasn't gone through all their funds and are not in a long-term care facility, a nursing home, and on Medicaid Title 19 already. So that's an acknowledgement that person has provided the care, kept them independent, kept them out of a long-term care facility, and that's a way in which things can be protected. That's something you want to take into consideration. But as we can see, knowing that we have options, one place it can begin is with the communication, with having the talk, keeping up to date with our legal documents. It's important that we know that if we did a power of attorney 25 years ago, is it still valid? Yes, it could still be valid, but you may have a problem, or your children may have a problem if they go to the bank and the bank wants to see a more recent document. So it's good to keep our documents up to date. It's good to know that there are options available to you so that you can take care of these situations. We want to know that if we become incapacitated, someone could immediately step into our shoes. And if we have a properly drafted power of attorney, we don't necessarily have to have a conservator appointed. What's the difference between a power of attorney and a conservator? A power of attorney is a document in which you can appoint someone in advance to be able to make healthcare decisions, to make financial decisions for you. By doing so, you are in a situation that you can immediately step into a parent or a loved one's shoes, pay their bills, have access to their accounts so you can pay all their expenses, and have a seamless transition to make sure that the person that you're appointing is the person you want in charge. Again, we want to make sure that a total stranger isn't making financial decisions for us because they've been appointed by the probate court as your conservator. And again, what's the difference between the conservator and the power of attorney? The power of attorney, we're deciding in advance who we want to make financial decisions for us. Now, that could be a power of attorney that's known as a springing power of attorney, where it's not effective until we're deemed to be incapacitated. A durable power of attorney says that even if I become incapacitated, someone can make decisions for me and they can immediately step into my shoes, and I don't have to have a conservator appointed, and I can have the person appointed. And there's language that should be written into this document indicating that if there's a legal and ethical way to protect what I've worked my lifetime for, I'm empowering my son, my daughter, my niece, my nephew, someone I trust to be able to protect what I've worked my lifetime for. A conservatorship proceeding is, there's two types of conservator. Conservator of the state means somebody would be in charge of all your finances, and conservator of the person. Under what they call an involuntary conservatorship proceeding, I would have to be found to be incapable of making financial or healthcare decisions, that I may be a danger to myself. And it's a formal proceeding in the probate court. It's expensive, and I am essentially stripped of my rights to make contracts, to make financial decisions, and ultimately to make healthcare or personal decisions. So the court takes that very seriously. But if we have a properly drafted power of attorney, if we have a properly drafted healthcare representative or living will or HIPAA or privacy forms, there's no need to have a conservator appointed. And again, there's no guarantee if we haven't specified in advance that the person who would be in charge would be the person who would be making that decision. So.
And there was, could you provide some clarity? We're getting some clients who come to us who they're finding that their financial power of attorney forms, which were crafted prior to 2016, are not being accepted by their local financial institutions. Was there some change in the law that maybe makes it necessary to update those documents?
Yes, there was a change in the state of Connecticut under the statutory language. That doesn't mean that if a power of attorney was drafted before 2016 that it should not be honored. But part of the reason that the state changed the law is so many people were being denied by financial institutions, being told the power of attorney was too old, the power of attorney didn't take into consideration the type of transaction they're trying to bring forward. That's why the legislature said, listen, we've had enough. We want to make this clear that it's been drafted after this date, that it will be honored and recognized by the financial institution. This points out another thing, Mark, that families should consider is going to your banks, going to your financial institutions and giving them a copy of the power of attorney, potentially even getting to meet, if it's your son or daughter, that they have it on record, that they have a copy of your power of attorney. They've seen the original, so that if a crisis occurs, that they've already met your family, and it's on record that this power of attorney exists. But that was a problem. That's why the law was changed. It makes good sense to have regular scheduled checkups, if you will, with your elder law attorney. We often have people come in and we'll look at the documents and we'll say, hey, everything's fine. You don't need to change anything. But at least it's good to have it looked at, so that in the event of a crisis, someone can step into your shoes and make those financial decisions. And that makes a huge difference if you're scrambling to try to get your legal affairs, your financial affairs in order to qualify for some of these programs. If someone could immediately step into your shoes and make those decisions for you, that makes a big difference. And it's well worth the time and effort in getting the documents in place so that you're ready to go in the event of a crisis. You know, we wouldn't drive our cars without insurance. We wouldn't live in our homes without insurance. Then we really shouldn't be putting ourselves at risk by not having the appropriate legal documents in order in the event of a crisis situation, so that someone immediately can try to protect what we've worked our lifetime for. So that's something that that's very, very important. But that was a change in 2016. That also points out the fact that the laws are ever changing, and sometimes they're huge law changes, like what happened on a federal level in 2006 when we went from a 3-year to a 5-year look back period. But unfortunately, even worse was the way in which they assessed penalties, that it truly takes 5 years, whether you're transferring $1,000 or you're transferring $1 million. If you don't fit within any of the exceptions, that was a big law change. And it's important that we are trying to keep ourselves up to date, like the folks who are listening in today, knowing that there are constant changes, but we want to keep ourselves educated. We want to keep ourselves up to date, so that in the event of a crisis, we're in a much better position to adapt and adjust and get the best results for ourselves or our loved ones. So that makes a lot of sense. That makes an awful lot of sense to do that. I'd be happy to answer any other questions if there are any.
Yeah, folks, so you can either use the chat box if you have a question for Attorney Tully, or if for orderly, you can unmute yourself and ask your question. And as we wait for any questions, again, we're part of, we're Hartford Healthcare Center for Healthy Aging. We have offices, 12 offices throughout the state of Connecticut at every county. If you have questions regarding aging, who does a service, what it may cost, who can help pay for it, certainly can be a resource. And Attorney Tully is a partner at Kilbourne and Tully out of Bristol, and he's one of resident elder law attorney experts that can certainly get your questions directed to. Any remaining questions? Let's see. Is there a reference to a packet? There was a reference to a packet from ktelderlaw.com. Yeah, so you folks, yeah, so you can reach out to Dan directly, or here at the Center for Healthy Aging. I'll give you our toll-free number, which is 1-877-424-4641. And you can ask for me, Mark Levesque, and we can make sure that you get that. Here's a couple other questions. What is your opinion on having a living will notarized? Many of my elderly clients can get 2 witnesses, but can't get it notary.
Well, the statute in Connecticut doesn't require that the living will be notarized, and 2 witnesses would be sufficient. It doesn't hurt to have that notarized. It's also important to make
it's
sure
not required.
It's not required in Connecticut.
Another question. Is the state doing asset recovery?
That's a very good question, and that's something that we didn't touch upon in the presentation, is that the state is required, like every state, in that if they participate in the Medicaid program, they have to have a state recovery provisions. What that means, if I am on the Connecticut home care program, and I'm receiving all these wonderful benefits in my home and staying independent, and I am a widower. When I pass, my family might be surprised to find out that my home was liened, because the state has the right to recover against my estate for the assistance paid out on my behalf. So the state absolutely does recovery, and that was one of my functions when I was at the Attorney General's office, was to pursue recovery on behalf of the state of Connecticut. And not only can they do it, it's required under federal law, if you participate in the Medicaid program, Medicaid Title 19, that you have some type of a state recovery provision in your state. They can come after assets, not just your home. Now, it's a little different, though. If we're a married couple and your spouse ran up a very large bill to the state of Connecticut under the Medicaid program, and the ill spouse passes before the healthy spouse or the community spouse, the state of Connecticut cannot seek recovery if that healthy spouse is living in the home, and they cannot come after any of the assets that are in the name of the healthy spouse. And, sometimes, Mark, people don't pursue benefits in which they're eligible for, that they're entitled to, for fear of a state recovery, that the state's going to come back and come after me. And that just doesn't make any sense, because, as I've just indicated, if you're the healthier spouse, if you're the community spouse, if you're still living in the home, there's nothing that the state can do to you if you are the spouse in the community, and you never want to pass up on benefits that you're entitled to. I mean, we've all paid taxes over the years. That's why the safety net is there, and it's discouraging if you see someone who's giving up on benefits in which they're entitled to, for fear of that the state's going to come after them and recoup it from their home or their assets, and that does happen. So
yeah, absolutely. Yeah, I've definitely seen it happen. Other questions from the group? All right, here's another one. How can an adult child get a key to our safety deposit box or have access to it?
Well, I would probably need a little bit more facts to answer that, but let me take a swing at it. If a parent has a safety deposit box and the adult child's name is not on it, or any of the loved one's name is not on it, you don't have access to it unless, of course, you have a properly drafted power of attorney. If there was no properly drafted power of attorney and the person who has the safety deposit box is now incapacitated, unfortunately, at that time, you'd have to go the conservatorship route, the conservator of the estate, meaning in charge of all finances, to legally be able to have access to the safety deposit box. The perfect example how if there was a properly drafted power of attorney, it would be streamlined that person could go to the bank with that document, show it to the bank, and the bank would enable them to have access to what is in the safety deposit box. So again, it proves the importance of having these documents properly drafted, in place, and ready to go in the event of a crisis.
Yeah, excellent question.
Yes, was.
Any other questions for Attorney Tully?
Well, the one thing, Mark, the folks, we'd be happy to get out information about having the talk. They can call you, they can call us at 860-583-1341. Be happy to get a booklet out to them. There's a lot of good free information at our website, KTElderlaw, ELDERLAW.com. As a matter of fact, we have a clip on there that when we were on Better Connecticut with Scott Haney, we talked exactly about having the talk and things that you might want to consider. So you might want to take a look at that too.
Excellent. Well, Attorney Tully, thank you for your time, your expertise, and it was very informative. And thank you so much. You have a wonderful day.
You too. Thanks for having me.
All right. Thanks, folks. Take care. Have a good day. Thanks for tuning in.